Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to look at the trial of Hannah Payne and specifically at the cross-examination of one of the prosecution's witnesses. Now, when you do a cross-examination, particularly in a criminal case, you're looking at a number of things. Does the witness have a bias? Does the witness have the ability, or did the witness have the ability, to see what she claims to have seen? You may recall the famous scene from My Cousin Vinny, where he's holding up two fingers, and the judge says he's holding up two fingers, and he has to say, now, Mrs. Smith, and only Mrs. Smith. But that was a good way of demonstrating that she did not have the ability to see what she claimed to have seen. And witnesses often do this. And then after they have had a chance to meet with the prosecutors and they hear what the prosecution's theory of the case is, many times they will modify their memory. I mean, they're really not trying to lie. They just modify their memory to encapsulate that which they've been told by the prosecution. And I think this witness is probably doing that. I don't think that she's has any intent to deceive the jury, but intent to deceive and the ability to deceive are two different things. And she certainly has the ability to deceive the jury. So in this case, the job of the lawyer is to point that out, to point out the fact that there might be differences in her testimony and that it might be a little too close to the prosecution's view of the evidence. Now, there are a couple of ways to do that, but the most effective way is not to just get up and say, well, you're a liar, you don't remember any of this, you're adding stuff to your statement. That is it's a legitimate cross-examination strategy in some instances where, a person's bias is manifest and the jury can see it. But in a situation like this where you have a third-party witness who has, she doesn't have a dog in the fight here, so she wouldn't have any real incentive to lie. She may just have a little difficulty remembering things. So what she does is she gives her testimony first, and let's take a look at the testimony that she gives on behalf of the state.
When you saw the Jeep jump the median and block the Dodge Dakota, when did the person jump out of that Jeep?
Immediately.
And when the person jumped out of that Jeep, where did they go?
Straight to his window on the driver's side.
Now, as you sit here in the courtroom today, do you see the person that was driving that Jeep?
Yes.
And can you identify that person by where they're sitting in the courtroom and what they're wearing?
Yellow, dress casual.
As you look at Hannah Payne throughout the trial here and perhaps throughout these segments, she's always seeming to be looking down. She's never making eye contact with the camera, and she appears to have been defeated already. And I think that's something that juries see, and I think they look at that as knowledge of guilt, which is why you always tell your client not to react to anything they hear in court and not to let it look like it bothers them.
Outfit right there.
Right, let the record reflect the witnesses identified the defendant in open court. When you saw the defendant cut Mr. Herring's vehicle off, what was her demeanor?
Your Honor, I judge speculation. She doesn't know Ms. Payne. She doesn't know what her demeanor would be. Therefore, I believe this is speculation.
Your response, Lady?
Your Honor, she can testify about anything she observed as far as the defendant's actions on that day.
So I'm going to overrule the objection. The witness can certainly testify as to her personal observation and what she concluded from observation.
Now, that objection was not for the judge. That objection was for the jury. Apparently, this judge allows speaking objections, at least short speaking objections. and doesn't address the objections up at the bench where the jury can't hear it. So essentially, what the lawyer is telling the jury here is, hey, this gal doesn't know Hannah. She doesn't know what her normal demeanor is. So, you can sort of ignore this a little bit. Now, the prosecution's response was absolutely accurate, but it indicates that she should have asked the question that way. What did you observe? What did you observe about her demeanor? So she can talk about actions and what she interpreted from that. There is an art to asking questions on direct that you can establish certain things without going overboard.
I did not see her in her Jeep when she got out. She was immediately aggressive. I didn't understand what was going on. I just thought it was like road rage at the time. Maybe I didn't understand, but that was the first time I saw her when she actually got out of the truck and was immediately aggressive.
Those two segments of the direct examination are the two segments that in cross-examination the attorney is going to go after. The two themes that came into this case through the opening statement of the state, where they indicated that she was violent and aggressive and that she jumped the median. So he's going to attack her on the jumping the median part, and he's going to attack her later on in her aggressive or her description of her demeanor. And in the first instance, he's going to do it by showing her things that she probably did not have access to, may not have had a chance to look at before she testified. And he's also going to impeach her with her statement. So let's watch that.
So your testimony you gave so far is that she jumped over the curb and cut this vehicle off, correct?
Yes.
Okay. And you saw where they ended up because you were right behind them or right in front of them?
Yes. Are you asking me for clarification?
Yes, sir. Were you in front of them or behind them?
I was.
Okay, now that is a good witness right there, because she's making sure that she understands the question and that she's answering the question that he really has. And this is a good way to avoid getting confused and then being impeached by making it look like you don't know what you're talking about. So she certainly did a good thing there.
Behind, really, I was like this, side by side, so they're merging, and they would have been in the next lane to me if he had have been able to keep driving, but there was a yield right there, so he's waiting for traffic.
So you say there was a yield sign there?
I believe so. Well, they need to yield to traffic because they were merging into a lane.
Okay, what I'm asking you from what you saw that day, did you see a yield sign?
I don't remember.
Okay.
All right, now that was a good thing, because now we've established that she has a little bit at least of loss of memory as to what she saw. She may simply have assumed that there was a yield sign there. Clearly, he would not be asking that question if there was a yield sign there, and he knows there isn't a yield sign. So he is letting her off the hook, but he's establishing that she may not be remembering things exactly the way she thought. And this is important because on closing argument, he's going to have to attack all of these witnesses, and he's going to have to show that a lot of their memories may have been corrupted. And I don't mean that in an ugly way, I mean it just in a factual way, that they may have been corrupted by the analysis of the state and by working with the state on the case. So he's done a good thing here in that regard. And one thing that's important to note here, he's not attacking the witness personally. He's not shaking his finger. He's not being aggressive toward her. He's just calmly and patiently nailing down things that she got wrong. But he's not calling her a bad person. He's not indicating that he thinks she's a bad person. He's simply getting the facts straight. Demeanor toward a witness is very important, because if a jury believes that you're beating up a witness, they may wonder why. And they may think that you protest too much. So his demeanor here in terms of how he's dealing with this witness is spot on. Now he's going to show her some photographs, and they're going to talk about whether it was possible or whether it was necessary for the driver of the Jeep, in this case Hannah Payne, to jump the median. And it's an interesting exchange. Let's watch.
What I have here, pictures of the end result from that day. Do you recall seeing this in this kind of manner?
Yeah.
Okay. And having seen that, is that a fair and accurate representation of what you recall happening that day?
Yes.
And that's exactly how you saw the vehicles at the end?
Yes.
At this time, Your Honor, I would like to tender Defense Exhibit number 6, number 4, and number 7. You see the median?
Yes.
Okay. And is there any need to jump that median for those vehicles to end up in that position?
No.
So, knowing where the median is from that picture, refreshing your memory from the pictures in front of you, for the vehicles to be in that position, was it necessary for a car to jump a median to be there?
No.
Okay.
So walking her through all of these exhibits and letting her look, he has now pretty effectively established that it wasn't necessary for Hannah Payne to jump the median. Why is that important? It probably doesn't have any real bearing on the issue of who was the aggressor or any of that. It's simply an illustration of how an eyewitness at the scene got things wrong. And you can bet that there will be some attempt at closing argument to talk about how eyewitnesses sometimes get things wrong and they get things out of order because they've just witnessed a traumatic event. So look for that in closing, but more importantly, notice the fact that he was able to walk her back from her original testimony and establish that it wasn't necessary for her to jump that median, which has been sort of a fulcrum in the state's case in this so far. Now he's going to bring out the statement that she wrote with respect to the events of that day, and he's going to impeach her with her prior inconsistent statements. Now, in order to impeach someone with your prior inconsistent statements, you pretty much have to show them the statements and ask a question, something to the effect of, well, didn't your statement say this or didn't it say that? But in this case, what he's doing is he's pointing out that there are things that are not in her statement.
So, do you recall writing a statement to the police on that day?
Yes.
I may approach Your Honor. Does that look like a fair and accurate representation of what you wrote that day?
Yes.
Is that your signature at the bottom?
Yes.
At this time, Your Honor, I would like to introduce Defense Exhibit number 8.
Any objection from the state? No objection, Your Honor. Submitted without objection.
All right, now that you've had time to review that document, did you ever mention about a Jeep jumping a median to cut off the truck?
No.
This is a really tough case for the defense, and you've just seen the two best moments that I think they had in their cross-examination of this witness. This witness didn't have bias, and she may have been mistaken about a couple of things, but most of her observations came through as honest and genuine, and I think it definitely profited the prosecution more than it did the defense. But it's a good look at how a lawyer goes after somebody who is going to be sympathetic. The jury is going to be sympathetic to them because they are there just to tell the truth, and that's apparently what they are doing. And it's obvious to the jury that somebody like this particular witness has no incentive to make anything up. I thought that in the grand scheme of things in this case, that the better option for this gal would have been to take a plea, but she wanted to take it to trial. I think because she just can't accept that she did anything wrong. And yet, as the testimony comes in, it more and more looks like she clearly did something wrong. And I think that is starting to weigh on her at this point. I don't have any idea how the verdict is going to come out. I think that's entirely up to the jury, and there may be people who are sympathetic to her point of view. There may be people on the jury, for example, who believe the police aren't doing enough to stop crime, and that when somebody breaks the law, as the gentleman did by leaving the scene of an accident, that somebody needs to step up and stop them. But even if you take that position, you can't get away with shooting somebody just because you're really ticked off or just because you're really scared. There has to be a sudden, unavoidable, deadly threat, and you have to be in legitimate fear of your life. And the only way for them to establish that is to put her on the stand. And I think that they probably want to avoid putting her on the stand if at all possible. But we'll have to see if they ultimately make that decision. So that's what I have for you today. Thank you so much for watching. If you have any questions, leave them in the comments down below, or you can always email me. And if you have the opportunity today, do something kind. Go out of your way, make somebody's day, and then come back here and see me at the beach tomorrow. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.